So we have a great panel here on generative AI and copyright between Megan Bannigan and Mark Ritzmann. I will let them speak a little bit more to themselves, but if we all want to get settled in, we'll get rolling.
Yes.
Hi, everyone. I'm Mark Ritzmann. I teach at Columbia, and I also work at Fiddler, so you just met Krishna, the big boss. And this is Megan.
Hi, everyone. I'm Megan Bannigan. I'm a partner at a law firm, Debevoise in Plimpton in New York. I focus primarily on litigating high-profile and challenging intellectual property cases. And as you can imagine, these AI issues are some of the most challenging cases that we have going on right now. I also teach at NYU and Rutgers. I teach advanced trademark law and false advertising, and I also teach fashion law. So, there's nothing like a lawyer panel to clear the room or throw cold water on all of the exciting things we've been talking about today. But that's not what we're here to do. We're here to talk about some of the practical realities and the practical implications you should be considering, and what is the landscape of the legal, what is the legal landscape? What are the regulations and laws you should know about? And how can we work within that legal landscape to make sure that we can continue to do all of this amazing work?
It was interesting that in both of the creative sessions, the word lawsuit came up. What I'd like to ask Bannigan to start with is just maybe take 5 minutes to go through terms, terminology, real quickly, legal definitions to set a framework and a context to exactly what it is that we're talking about, and when something is a copyright infringement, when it rises to that level versus fair usage, what are some of the case laws and what are some of the precedents, and maybe we can take 5 minutes and start with that, and then we'll move into some of the other topics.
That makes sense. And so I was thinking about this question this morning, and I said I need slides because I don't want to put you all to sleep, so I can at least give you some pretty pictures to look at as we talk about this. So let's go to the next slide. We're going to do this part quick, but what is intellectual property? It's a term that you hear all of the time, but what are we actually talking about, and why are these things that you need to know about when you're building your AI or using AI? So the basic types are trademarks, copyrights, patents, trade secrets, and right of publicity. There's two basic underlying themes that run through all of this. Is my creation protectable? And is my creation allowed in the first instance? What I created, have I infringed on somebody else's rights? And you'll see that these themes run through all of these types of intellectual property. So, trademarks. None of these images were AI created, although as I sat here and listened to Leo, I wished I had thought of that to put these on the slide, so maybe in the next presentation I will. But what are we talking about here? We're talking about qualities of a brand that are source identifying. Obviously the name, the logo, the design, sometimes it's even the shape or the configuration, like the Toblerone box that you see here. Color can be protected and can be owned. The Tiffany blue box, you see that blue and you know that it's Tiffany. And there are even some interesting things beyond what's normally protected as a trademark, like sounds. Think the Netflix sound when it starts. Smell. Did you know that if you create something that smells like Play-Doh, you are infringing Play-Doh's trademark? They own a trademark in the smell of Play-Doh. I don't think that's going to be an issue for us, but it is a fun fact. Color, Tiffany blue. And so the long of the short of it is something that identifies a brand. You see that element, you know that it belongs to that brand. If I ask DALL-E 2 to create an image of somebody wearing red-soled shoes, I've never said Christian Louboutin, but Christian Louboutin owns that trademark in those red-soled shoes. He's fighting for that trademark in almost every country around the world. You don't want to do that. That's going to be a problem. You need to know if you're creating things that some of these could be an issue. The next is copyright. Copyright. So copyright is the big one. Copyright is the term that is thrown around constantly with generative AI. And there are so many questions about copyright. One, are creations that you make protectable? You know, if I make something, can somebody else just take it and use it for any purpose because I have no rights over it? Two, you know, how are these things created? How have data sets been created? How has AI been trained? Am I using somebody else's copyrighted material? So what do I mean by copyrighted material? Literary works. And literary works is broad. It's not just those award-winning novels. It's an article, any blog post that's posted online. Those are your words that you've strung together. It's your creation. You have protection over it. Somebody cannot just take it and plagiarize it. Literary works also includes software code. And software code is known as a literary work for copyright protection. You can't just take somebody's software code that they've created. That person has rights to it. You know, also dramatic works, musical works, sound recordings, motion pictures, sculptures, etc. It's original works of creation. Okay. Patents, we can do this one quickly. Most of you, I'm sure, are familiar with patents. These are for new and useful inventions, novel things, non-obvious things, functional, useful things. There is a subset of patents that aren't often talked about. Those are design patents. And so we usually think of a patent as it protects some utilitarian or functional purpose. Design patents actually protect ornamental features. So a picture of something, a design, a drawing, an item of clothing. So you know, even when you're creating generative AI, you know, you might not realize that patents are at play too. Okay, trade secrets. These are some old trade secrets, but trade secrets is highly confidential, valuable information that your company or you have, you keep it secret, and you take steps to keep it secret. What does it mean to take steps to keep it secret? You have confidentiality agreements and NDAs, and it's just the most highly sensitive information that you have in your company or you have with your creations. And again, the key to proving you have a trade secret is that it has to actually be secret. So I'll give you a spoiler alert for later. If you input that into AI or some kind of tool, is that secret anymore? Or have you just lost protection over it because you've put it into a data set? And you know, what presentation is not whole without a picture of Lindsay Lohan in a bikini? This is right of publicity. And this is, you cannot use somebody else's name, image, or likeness without their consent. This is an old case. This is a case where Lindsay Lohan sued a video game, Grand Theft Auto, because she claimed this person in a bikini was actually her. She lost. But had it really been a picture of Lindsay Lohan, the game would have had a problem. And so to the extent you're asking AI to generate pictures of certain people, you might have a problem. There's also been some questions of, you know, create me some art in the style of Van Gogh. Are you using Van Gogh's likeness, or not his image, but his name, his likeness? I think that's a stretch, but there are current ongoing litigations bringing right of publicity claims based on the style of type of work. So that's something you need to think of as well. So look, those are our main categories of IP. Let's turn this back to actually generative AI, and you can understand why we're talking about these categories of IP.
I think one of the underlying currents is clearly not, well, at least as far as I know, none of the copyright laws or these laws or this construct were written with this world in mind.
That's for sure.
Is there anything that you're aware of that, you know, then we also talked about in prep about the idea of regulation. Is there anything that you're aware of that you're seeing that may be working its way through that could set a precedent or could apply or could in some creative way to apply to maybe this type of legal work that's coming our way?
I mean, this happens over and over and over again. We saw it with the introduction of the internet. We saw it with the introduction of the domain name system. I have several cases right now involving NFTs, and people in the courts are going absolutely crazy. And I'm like, this is just like when the .com started. Like IP does not change just because we have a new medium. And I think that's the one thing that's important to remember is we have the laws, we just need to adapt them. And it's what makes my job so fun, frankly, because we do keep adapting them. Now, there is a regulatory framework that we're seeing for AI. There's a new EU AI law. It's still in draft form, but it is expected to take effect later this year. And the EU law says there are different risk levels depending on the types of AI, and that if you're dealing with this, you're going to have to do a risk assessment. And so it has all different things where you're going to have to assess, and you're going to have to monitor, and you're going to have to keep track of. Now, the United States doesn't have anything like that yet, but one will follow eventually. And what we are seeing in the United States is state-specific laws that are coming into play, and also sector-specific laws. So right now, Colorado, I think in one of the most, the biggest regulations that we've seen so far, Colorado has passed an insurance law that says if you're using AI in the field of insurance, there are certain things that you have to do. New York recently passed a law dealing with AI in the hiring process. So if you're using AI tools in the hiring process, you need to have certain audits of those tools to make sure that there's no bias. And again, this is just small pieces, but the states are going to catch on. They are catching on. There's been lots of talk about this. There are commissions formed. The Federal Trade Commission just this week put out a warning and said, hey, if you're advertising AI capabilities, we're watching you. We're forming a new task force to look at this specifically, and you better make sure you're not over-exaggerating those AI capabilities. And so that's just one example, but we're going to see this over and over again. And aside from that, we have several current cases that are pending, some of which I'm sure you've heard of already, but they go back to these same questions that I said in the beginning. You know, can AI content be protected under the existing IP laws? I think that the answer is yes, but we're going to have to get creative. And frankly, Leo's presentation today gave me some great ideas, and I can talk about that in a minute. But then also, is it infringing our current IP laws?
Yeah. This is, I mean, a little bit of a crystal ball and philosophical question. One of the things Eric Schmidt said this morning is this is not human, this is math, and this is search. So if blog posts or those writings are copyright protected, and this is, in essence, using that as a data source, do you see something like, is it going to have to change by n degrees, or is this unavoidable, or can you sort of look into the future and maybe opine on that?
So, right, so that's the big issue right now. Everyone has been, or everyone, or the agencies, or the bodies that regulate this have been clear. If it's not created by a human, we're not giving it copyright protection, we're not giving it patent protection. You know, these patents and copyrights exist. We are trying to incentivize human creation. We're trying to incentivize monetary reasons for creating this. We're trying to protect goodwill. And we're not just going to turn this over and say a computer can do it, because then doesn't that harm humans? But then you hear the story from Leo and all the work that went into just creating the image that's used on the tote bag for this event, and you realize there's a little more to it. And there are some people fighting this right now. So if you've heard of Stephen Thaler, he is an AI activist. It's the only way to describe him. And he currently has litigations pending in several jurisdictions around the world: the United States, Australia, the EU, the UK, there are several others. And he has a AI tool called Debevoise. And Debevoise created this image that you see on the screen here. And so far, every single organization that he's applied to for either patent or copyright protection has said no. Straight up, no. And so he's suing them all, saying you're wrong, that this is, I created this, I am the creator, I made this tool, I instructed this tool to do it, I'm the creator. The patent office, he's already done in the patent office in the US, they've just said no. He has sued the Copyright Office. The case is still pending, and he basically said, like, your decision was arbitrary and conspicuous. It's not right. Again, I made this. I should get copyright protection over it. I'm a little doubtful that he will get it, because what he's not doing is showing those extra steps that Leo described, for instance. Like, you know, there's going to be some minutia here. Was it really just a machine that did the work, or what? How did you do the work? How did you create this? More interesting on the copyright front, though, is this Zarya of the Dawn comic book. And so this decision just came out either last week or the week before. And this is, it's a comic book by Christina Kashtanova, and she puts this out. And by the way, you can see these are the images here. It looks, the woman in it looks very similar to Zendaya. So there hasn't been a right of publicity action yet, but it's one I could see brewing if Zendaya doesn't agree with her image being used here. And so what Kashtanova did was she created the images for her comic book using Midjourney. But then she put the text in and she put the images together in a compilation. She applied for copyright protection, and she did not disclose that AI or Midjourney played any part in this. And the Copyright Office said, yep, this is core copyrightable material. This is art. This is the compilation of images and text. You get a copyright registration. The Copyright Office then got wind that Midjourney was involved in this, and it issued a revised opinion. It said, oh, no. You actually don't have copyright in these images created by Midjourney. They were created by AI. They're not protectable. But you do have copyright protection in the text and in the way that you arranged the images. The author put out a text afterwards and said, oh, this is great. This is a win for creators. And by the way, my lawyers are looking at creative ways that we can explain to the Copyright Office that I actually did create these images, that there was more to it than just typing a prompt into one of these applications. But so some people see it as a win that there is some copyright protection available for this, but what are you actually protecting? Is anybody else going to take these images and arrange them in the same way with this particular text? The protection is so thin that it's really problematic. And then I'll address these very quickly. The other big copyright cases. Sorry, it's like I have to press it a certain way to get it to work. There's two cases pending, the Anderson case and the Getty Images case. They've both sued Stability AI, and they've sued, is inclusion of copyrighted material in the training data infringement. And so these are tools that scrape the web for images to train the AI on. You can then, of course, put in the text prompt and get an image. Getty and Anderson are both saying, those are my copyrighted materials. Any image you create is a derivative work from my copyright. A derivative work is you have taken my copyrighted material and you have changed it to create something new. But what a copyright entitles you is I'm the person that gets to decide how that work is used. You can't take it and change it. That is a derivative work of mine. That's not something you're allowed to do under the copyright law. And so these are going to be really interesting to see how these cases turn out. And then there's also a similar case. Oops, I went one too far. Maybe I went one too far this time. Anyway, there's a similar case where there are some unnamed plaintiffs suing Microsoft and GitHub, similarly about the Copilot application, which spits out code, and that scrapes GitHub for code, and then will spit out some new code for you. And what the plaintiffs are saying in that case is through OpenAI, we had a license, an open source license, and I said you could use my code, but you had to attribute it to me, and you had to put a copyright notice, and you also had to include terms of service. None of that is happening with what's coming out of Copilot, and therefore this is an infringement. The defendants have filed a motion to dismiss and said there's nothing here, we shouldn't even have the case at all. So, these are really cutting edge cases. They're not gonna answer all of the questions. I predict what's gonna happen is many different courts are gonna look at this. Many different courts are gonna answer the question in opposite ways. And we're gonna have a number of years in which it's a little bit unclear what you're actually allowed to do. So you're gonna have to be pretty careful.
Interesting. Turning a little bit, sort of crystal ball now, is within business models and business context. And I think right now most applications that have this built in or have it embedded are personal use applications. So summarize these meeting notes, write emails for me. Some students just write papers for me. In a future
It's
state,
problematic, yes.
In a future state, if there were to be a scalable, public-facing company with thousands and thousands of users with this embedded underneath it, is there a way that you would advise that how could you manage risk, or what you would need to watch out for, or what the possible penalties or remedies could be?
So it's so important to monitor this. I mean, we've put out some blog posts at my firm about this. Like, you're using ChatGPT. Should you let your employees use it? What should you be doing to protect yourself? And because, I mean, part of the problem is that there's not regulations yet, and the law is not decided yet. So it's a little bit up in the air. But AI governance is more important than ever, especially because it is up in the air, and what you need to do are take steps to protect you as an employee using it, to protect you as an owner of a company where employees are using it, or even as somebody who is using it to develop your creations. And so for companies, the advice we give is, first of all, take the time and do a risk rating. Like, look at how you're using it. There's different uses of these things. If I'm using ChatGPT for personal use or for business, what am I using it for? Am I putting confidential information in there? Am I putting information about employees or information about clients? Like, there's privacy concerns. There's confidentiality concerns. Am I putting my copyrighted creations in a place where they might get scraped into a data set? And do I not want those there? And do I not want somebody infringing them? So do a risk rating. Is it a high, medium, or low risk? And then decide, is it worth proceeding? Take inventory of what you're doing. It's very important to take inventory. Make sure you know what your employees are doing, what you're doing in the creation, just in case you have to talk about it later. You should train people. You should be transparent. So if you are putting out material into the world for public consumption that has been created by AI, don't hide that. Let people know that it's been created by AI, because then you won't be misleading them. We're worried the FTC is looking at these. Are you misleading consumers? There's Unfair and Deceptive Practices Acts that the state AGs are dying to get in on this. Like, don't have it be you. There's just regular false advertising. So you need to be very careful there. And it's just, keeping records, knowing what you're doing, and paying attention to it is the most important thing. The other thing I would say is, if you're a creator and you want to protect your works so other people can't use them, pay attention to copyrights. If it's something really important to you, register your copyright. Opt out of data sets if you're given the option. And also consider licensing terms. Like, if you're putting something on the internet, consider more stringent licensing terms. If somebody is using it, make sure it's clear that you can't use this. Or you can't put this as part of a data set. You can't use it as part of AI because it will protect you later. So there are lots of different things you should be thinking about.
There's 2 minutes left, so I'll end with this. Are you optimistic?
I am.
We're going to be able to figure this out. It's not going to be a shit show for the next couple of years, or maybe it is, or maybe it's both.
So I laughed when Sydney made this comment on the last panel, and she said, I'm a lawyer, and I just laughed.
The buzzkill session.
Totally, I'm here to, like I said, to start. I'm going to throw cold water on all of this. Absolutely not. I'm totally positive. I believe, when you hear, I keep bringing up Leo's presentation, but when you hear presentations like that, there is more to it than simply putting a prompt into a AI application. I think that these applications can be so useful, but like I said, you just need to pay attention to what you're doing every step of the way. I don't expect you to leave this presentation saying oh, I know exactly what I need to do, in order to make sure I have no legal issues. But what I want you to get out of this are the buzzwords of what you need to pay attention to, who owns the IP? Am I using confidential information? Are there trade secrets? Are there privacy implications? Is there anything I'm doing that's unbiased? I'll give you a quick example. In Hungary, now again, this is not the United States, there was a company that was using an AI tool to monitor customer calls, and they were taking the tones of the customer voices to see are our customers happy, and they were using that data to analyze it. They ended up having to pay the EU a 700,000 euro fine because it said you were using this AI data, you were taking it for your data set without getting consent from the consumers. 700,000 euro is a lot of money if you're a startup company trying to start something. So again, just pay attention to what you're doing, and there are a lot of resources to get legal advice on these types of things.
Thanks. I think that's all the time we have. Great, thank you.
Happy to answer questions after.